My talk is on the duty of therapists to third parties, and I'd like to begin with a preliminary statement of basic idea in law. That is, a tort involves four concepts: act, damage, causation, fault. Act, voluntary act, damage, injury, causation, direct nexus from act to harm, and fault, which is based on a breach of a duty. And it's on causation and duty that we find problems in this area. The courts always say that there has to be a limit to liability and to available insurance coverage. And it is through the concept of causation, or primarily duty, by which the courts can limit liability. Every first-year student in law remembers the famous case of Palsgraf versus Long Island Railroad, in which a train conductor pushed a passenger carrying, unknown to him, fireworks under his arm, and in pushing him, the fireworks dropped. It caused a shattering, and down the platform, scales fell on Mrs. Palsgraf. And Judge Cardozo said, in a beautifully written opinion, that there was no duty owing to Mrs. Palsgraf, there was no foreseeability of harm to Mrs. Palsgraf, and there's no concept of transference of negligence from one party to another. Yes, if the passenger had been injured, that's one thing, but Mrs. Palsgraf would have to sue in her own right, and it was not a foreseeable risk to her. So the question then becomes, can therapy or care of a patient result in a foreseeable risk of harm to a third person? Pamela Fried has pointed out that in the case of recovery of memory, that not only the patient, but the third party and all the parents and the extended family may be injured by this process. So the question then becomes, do these third persons other than the patient, have a cause of action? And so policy lines that are somewhat arbitrary are drawn to narrow the scope of duty or actionable causation. To illustrate this, two recent cases from the Illinois appellate courts and Pennsylvania courts reaching different opinions. In one case, in the Illinois case, there was negligence as to the patient in failing to advise the patient regarding an infectious disease, and third persons were injured. Well, the court said there was no duty owing to the third persons, and a dissenting judge said, well, at least you could draw the limits to include the close members of the family, and the appellate court declined to do so. In a similar case in Pennsylvania, they extended the duty to include members of the family. Well, we come to California, where the Ramona case occurred, about which Mr. Richard Harrington yesterday spoke most eloquently. In 1980, in a well-known case, Mullion versus Kaiser Foundation Hospital, on which the Ramona case based its decision, the physician incorrectly and negligently diagnosed his patient's illness, syphilis, and directed the patient to have her husband tested as well, and he suffered emotional distress allegedly as a result of this. Well, in Mullion, the California court drew a distinction between direct victims and indirect victims or mere bystanders, on which there are other limitations. And so in Mullion, the court said the husband was a direct victim of the negligence of the physician. Then we had, in the mid-1970s, another famous case that's become a household word in psychiatry, the Tarasov versus the University of California that used a little different theory. In Tarasov, as all psychiatrists know, there was a question of whether a counselor, a psychologist, owed a duty to third persons who were threatened by his patient. And as it turned out, this patient killed Tatiana Tarasov, whom he had expressed a threat to include. Well, this was a pleading case, a question of whether there was a duty. And generally in the law, there's no duty to come to the rescue of another, but there is a duty when there is a special relationship. Well, there's a special relationship between a physician and a patient. The physician must aid the patient. The question here is, does that special relationship also include a special relationship to a third person? And the California Supreme Court, that's always been known, at least at that time, as the so-called progressive court, said that the special relationship between the physician and the patient also included created a special relationship between the between the physician and the third person. So it didn't matter whether or not the psychologist was negligent in the treatment and whether there was a direct harm. The very fact that there was this special relationship created a duty to take care with regard to the third person. That's the way the California Supreme Court put it. So that means that from the Tarasov case, even if the patient had seen the therapist momentarily without any opportunity for any therapy, there would be a duty to the third person. So B, a patient sees A, the doctor, immediately without any treatment, without any negligence in treatment, that creates a duty between A, the doctor, and the third person. Well, those were the two possible approaches that could have been used in the Ramona case, as everyone knows, and it's been much talked about at this conference, the revival of memory case. And so the court in the trial court in Ramona based its decision on the Mullion case, namely that the father was a direct victim of the negligence of the therapist. And let me quote a few paragraphs from the trial court's ruling. So it's the whole question of whether there is this duty. The court said, this lawsuit is a compelling one, and it's a compelling one because it not only has the novelty of new and current legal issues, but also because it has a salient emotionalism to it. The most interesting and compelling and difficult issue in this case is the question of whether a father may maintain a lawsuit against the therapist or other health care providers of his daughter, alleging that he was damaged by their negligent treatment of her. And he goes on at some length to say that this case falls within the purview of the Mullion decision some years early, in which the court said that the third person was a direct victim. Now, the question that has troubled people in the mental health profession is whether, if this decision is followed by appellate court decisions in California or elsewhere, is whether or not it opens the door to litigation by any person who is aggrieved by an interpretation made by a therapist to a patient. And needless to say, that thought has caused vibrations within the mental health profession. At the 1994 annual meeting of the American Psychiatric Association, Dr. Judith Herman, author of Trauma and Recovery, for which she got a prize, said this about the Ramona case, quote, "The fact that a third party was given standing to speak on malpractice because he was not happy with the treatment of his daughter really opens the door to permit anyone who is dissatisfied with our treatment of any patient to lay claim against us, close quote. Well, in the Mullion case, and somewhat in the trial court's opinion in Ramona, they circumscribed to whom the duty was owed, not to the world generally, not to every member of the family, but to those that suffered, it could be said to be near relatives in which there was a direct injury. Not one and all could bring an action. Well, in the same vein of thinking, like Dr. Judith Herman, Dr. Thomas Goodheil, who's at Harvard and testifies frequently, I believe he testified in the Ramona case, asked this, testified for the defendant. Whose therapy was this anyway? Should the father have been called in to approve each interpretation as it occurred to the therapist? Should the father's consent to the therapy have been sought even though the patient was a minor? Should the patient herself have been warned in some caricature of the warning needed in a forensic context that her therapy might conceivably be harmful to her father's peace of mind? Close quote. About that time, there was a Murphy Brown television program in which the husband was told by the therapist that his wife is the cause of all of his problems. And the therapist urged the husband to not be so passive, but to be aggressive with his wife. So he went home and he took this advice and he took out his anger on his wife. And the wife then came complaining to the therapist. Where do you get off telling my husband that I'm the cause of all of his problems? Close quote. And now Dr. Goodheil poses this hypothetical scenario. Let's say a young man comes to treatment to work on trouble with relationships. A few years into psychotherapy, without any prompting by the therapist, the patient decides that the problem has been his failure to acknowledge that he is gay. Working this issue through, he feels much better until he tells his parents, who are homophobic, and become outraged at this news. They decide to sue the therapist for implanting foreign ideas or brainwashing or whatever, close quote. Well, this scenario that Goodheil poses is what law professors, I suppose, would call a parade of horribles or a slippery slope. The important fact is that in Ramona, the therapist operated on the basis of unsupported beliefs, and they urged the patient to blame someone for their problems. They base their interpretation on unscientific suppositions, and as a member of the advisory board here testified, Dr. Harrison Pope, there was no basis for correlating this eating disorder that Holly Ramona suffered with any sexual abuse. And in the Ramona case, the jury was specifically asked to answer specific questions, and they did. And they said the defendants were negligent in providing health care to Holly Ramona by implanting or reinforcing false memories. They caused the plaintiff to be personally confronted with the accusation that he had molested Holly Ramona, and the plaintiff, as a result of it, suffered damages. Well, that same year, in 1994, you have somewhat of a different decision in Texas in Esther Bird versus WSW, in which a psychologist, Esther Bird, examining or supposedly examining a 6-year-old, reported that he had been sexually abused by the father. Well, the decision one could, in denying any action, could be based on immunity in reporting to a court, or the court went on to say that in this day of sexual abuse, therapists ought to be encouraged to make reports. But that's really dicta. In a case that's somewhat ignored, but was widely publicized in the late 1970s, was a case in Boulder, Colorado, in which a mother whose 25-year-old son had sued the mother had been sued by her son for, quote, parental malpractice. Family immunity had gone by the wayside, and so parents can sue children and children can sue parents. And so she turned around and sued her son's psychiatrist, Dr. Jeffrey Anker. The psychiatrist, had encouraged the son to sue her mother for therapeutic reasons, very much like in the Courage to Heal. There's this encouragement to confront the parents. One of the problems notable problems in bringing suit against a therapist is getting the records. Mr. Skip Simpson, from Texas, who spoke yesterday, had suggested one way of getting records is, like in Texas, is to claim that the therapist is incompetent, and on that ground get the mental health records of the therapist, which they may not like to divulge or would be reluctant to. Because the father, the third party, or any other member of the family is not in a treatment relationship with the therapist, the privilege doesn't belong to him, and therefore he could not waive the privilege. In the Ramona case, as I understand it, the daughter, Holly Ramona, had sued the father and thereby had waived the privilege that she had had with her therapist. Or perhaps if Gary Ramona, the father, had been seen as a patient, likewise. Another avenue is for the parent, this may not be a desirable type of procedure, is to join the patient, the daughter, along with the therapist as joint defendants, and in that way the privilege would be waived. But at any rate, unless you have that scenario, there's difficulty for a therapist to obtain, difficulty for the third person to get records of the therapy that went on between the therapist and the patient, if they would be needed. The same problem of to whom is a duty owed is involved in bringing a suit against a publisher or a distributor or an author of a book. And as has been mentioned at this conference, as Mr. Clancy had noted, there's been a suit against the publishers of and authors of numbers of books. Can anyone now bring a suit against Karl Marx? Well, to whom does he owe a duty? It's the same problem. The courts are concerned, to whom do you owe a duty? There have been some interesting cases in this line. In Hertzie versus Hustler magazine, a 14-year-old died as a result of, suffered as a result of autoerotic asphyxiation. And they brought suit against Hustler magazine. And the Fifth Circuit said that the First Amendment protected the magazine. There was a strong dissent, and the dissent had a basis in saying that the First Amendment does not, in all cases, preclude tort suits. There's suits for defamation, misrepresentation, etc. The real problem in these cases is proving causation, that is, that the rap music or other literature causes the harm, and also the very difficult problem of duty to whom. When there are a lot of advice columnists that write every day, give all sorts of advice. Well, you may say, well, there's a particular advice to a particular defendant. I had the opportunity one time to ask Ann Landers whether she had ever been sued for any advice that she had been given. And she said one time she had gotten a letter from someone who said that she was tired of being asked what she does for a living, and tired of saying she's a housewife. And Ann Landers advised, well, say you're a prostitute. That'll put them off. So she followed this advice, and unfortunately she said it on the street in the hearing of a police officer. And she was arrested and brought suit. Well, you might argue that there was a direct link between that advice and the... Well, to conclude, there's, of all the cases, there's the mushroom case, etc., in which they either say there's no duty or no proof of causation. But there's a case of Barden versus HarperCollins in which the publisher of the book, The Courage to Heal, is sued, and the reader of the book, the plaintiff, took the advice in hiring a particular lawyer to represent her. They set out the qualifications of the lawyer. Well, actually, he didn't live up to these qualifications, and it was alleged that there was negligent misrepresentation. And the case fell on the ground that there was no duty owed. The only types of cases that are successful is if the book can be claimed to be a product, and under products liability, you don't have to prove fault or duty, simply act, damage, causation. And so if you have a manual, like Sears Roebuck might have a manual how to explain the operation of a manual saw, and as a use of the manual, the user is injured, well, the manual might be considered part of the product, and an action then under products liability where it's not necessary to prove fault. Well, thank you very much.